Hi, my name is Janice Switlow. Good afternoon. Today, I would like to discuss historical as well as current and future outlines and possibilities for Dene in the north. The reason this is necessary, I feel, and why I've spent so much time, almost 2 years now, digging into where things are at and how they came to be, is that I hear a real disconnect between what Dene speak of and say they stand for and want, and what's actually being put into written documents, for example, which, if standing alone and there is nothing else done to ensure the preservation of Dene as a people, as a country, can have really far-reaching consequences for future generations. So I felt it was important to spend this time and to share with you a bit of a briefing on what I've discovered, what I find, and what my recommendations are. And I will keep this brief. At any time, of course, I'm quite prepared to spend time with you getting into more details. But for now, I think this is sufficient to cover some reminders and to flag where you seem to be heading and what these next stages, these next steps, I call them transitions, from casting off the unlawful interferences of Canadian governments and preserving and exercising the sovereignty of Indigenous nations. And as I said today, I'm focusing on Dene. So here I'm putting up a map that shows the extent of Dene country. And people don't tend to see this anymore. For example, I have an original edition of the Handbook of Indians of Canada, and in subsequent editions, you will not find this map. It's been culled. So here I share with you the extent of the Dene, and I'm just going to read what this text covers in terms of its knowledge, the observation of the Dene in the area at the time, and this is in the early 1900s. Athabascan family. Now remember, nations are built on language. And so, far from the standalone individual Indian bands or First Nations that people tend to refer to them as today, the Athabascan family is quite extensive, the most widely distributed of all the Indian linguistic families of North America. Formally, there's treating you as dead and gone, but that's not the case. Extending over parts of the continent from the Arctic coast far into North Mexico, from the Pacific to Hudson Bay at the north, and from the Rio Colorado to the mouth of the Rio Grande at the south. A territory extending from more than 40 degrees of latitude and 75 degrees of longitude. The languages which compose the Athabascan family are plainly related to each other, and because of certain peculiarities stand out from other languages with considerable distinctness. The wide differences in physical type and culture and the differences in language point to a long separation of the family, certainly covering many centuries. Now, of course, that's through no fault of the Dene themselves, but rather the consequences of actions of those coming to your shores. Geographically, it consists of 3 divisions: Northern, Pacific, and Southern. The Northern Division, known as and they've spelled it this way, Tinneh, or Dene, the name they apply to themselves, consists of 3 groups: the Eastern, the Northwestern, the Southwestern. And I'll go through and describe this at length, the territory involved. The Eastern, the Northwestern, the Southwestern. The Eastern group occupies a vast extent of continuous territory, bounded on the east by the Rocky Mountains and Lower Mackenzie River, on the south by the watershed between the Athabasca and Lower Peace Rivers, Athabasca Lake and Churchill River. To the east and north, a narrow but continuous strip of Eskimo Inuit territory bars them from Hudson Bay and the Arctic Ocean. Their neighbors on the south are members of the Algonquin family. This group seems to constitute a cultural area of its own, rather uniform and somewhat limited on its material side. Very little is known of the folklore and religion of the people of this region. The principal tribes are the Yellowknives, the Dog Ribs, the between Great Slave and Great Bear Lakes on the Mackenzie River, beginning at the north, the Hares and the Slaves, Chippewan on the Slave River and Beavers on the Peace River, and so on. Now it says that recognizing certain individuality, these tribes had little coherence and were subdivided into family groups or loose bands, and recognized rather a patriarchal government and descent. Perhaps the strongest authority was that exercised by the leader of a hunting party, the difference between success and failure on such a quest being frequently the difference between the existence or extinction of a band. So it's important that, and it says the tendencies of the members of this family to adopt the culture of neighboring peoples is so marked that it's difficult to determine and describe any distinctive Athabascan culture, or indeed to say whether such a culture ever existed. Now remember, this is through the lens of bias that happens on contact and not actually speaking their languages or being able to properly assess the distinctions of your societies and how you exercise your governance. But my main point on this is the extensiveness of which your people cover this part of the world. Now, the effort is, and of course, they kind of left you alone for the most part. They didn't see that there was a lot of opportunity for profit in your area, harsh kind of living conditions, etc. Fur trade, of course, but then that changed considerably over time. But eventually, oil and gas caught attention of the people who were responsible for assessing resources, and they started to drill and explore, and it was pointed out that there was no lawful ability to do that because there was no treaty in place. This leads us to Treaty 11 being formed, and I'm going to take you through some key provisions of that treaty now to remind you who the parties are and what the terms of that actually are. So you'll see here that it starts with describing who the two parties to the treaty are. Articles of a treaty made and concluded between His Most Gracious Majesty George V, King of Great Britain and Ireland, and of the British dominions beyond the seas. That's the party of the first part. And then, and it says of the one part. And the slave, Dogrib, Lushay, pardon me if I've mispronounced that, Hare and other Indians, inhabitants of the territory within the limits herein defined and described, they're represented by their chiefs and headmen of the other part. So remember, there's two parties, the indigenous nations and the crown, the king. Now, under all treaties, the treaties entered into by the reigning king or queen of the time, those treaties remain in place when that king or queen dies and is succeeded by their offspring. Now, everybody has taken great pains to say, we didn't give up our land. Well, you didn't. This treaty is very clearly setting up the crown as your head tenant. When I say your, I'm speaking of Dene as a whole. I'm not speaking of individual communities, families, or bands. It's the Dene Nation as a whole. There are not individual bands listed as parties. You'll hear, remember, the slave, Dogrib, Hare. These are entities within the larger Athabascan family that are considered the Dene. And you'll see it goes to describe the areas, and remember, it does not include the water. It'll go to, the bank of the river, that sort of thing. And it also says, okay, so all your, Indian rights, titles, and privileges whatsoever to other lands, including Yukon, Northwest Territories, because of course that's where the extent that you've also is part of Dene, as that original map that I showed you outlines. But here's the key terminology. It doesn't end at that. There's no payment, there's no lump sum payment that says this is to purchase your land. Instead, it says to have and to hold the same to His Majesty the King and his successors forever. To have and to hold are terms of a lease. They're standard form. It says who is the landlord and who is the tenant, and for how long does this arrangement last. you do not find to having to hold in any sale or conveyance of land. And if you look at any other treaties in other parts of the world where there's been handing over of land full sale, where the original owner is terminated and the new party becomes the underlying title owner, that doesn't exist here. So what was happening? The land was being cleared of the individual usages. So under any use of land, there's always a tenure system. There's something worked out under self-government that says, this family is trapping here, this family resides here, we all come together in the summer to process fish here. There's an elaborate system of usage of land to ensure that everybody is provided for and survival is maximized. All of this did, and you'll notice these annual payments, they go to individuals. They're members of bands that get those payments. There's no annual lump sum payment. That's to reflect that in order to make way for the head tenant, those individual usages under Dene law were being removed so as to insert the Crown as the head tenant. In doing so, it did not terminate or remove Dene law. The law of the land remains Dene law. It's trite to say that where the land is, that's the law that applies. Because there was no sale of the land under treaty, but rather only a leasehold interest established. That means Dene law still applies. But the Crown comes in, it has the right of head tenants and can do certain things with its interess. It also provides, of course, that you can set aside reserves. Now, a lot of people have been concerned about not being able to have access to the land, because of the experiences they saw further south, where people were being confined and starved and things like that. All of stuff that was not lawful, by the way. But under the treaties, in any kind of treaty that's entered into, there can be reservations. That means a country comes in and says, we're okay with this, but we don't agree with Section 21 or Article 21. So we will join in and sign in with the reservation that Article 21 does not apply to us. We're not agreeing to that article. That's considered a reservation. In this case, we're talking about establishing the Crown as a head tenant. The reservations are that the Crown will have these rights of head tenancy, with the exceptions of those areas reserved out. Reservations out of the land rents that are to be retained by the Dene and fully under their jurisdiction. Now, I don't have time to get into how the Indian Act has exceeded its authorities and unlawfully and unconstitutionally inserted itself into the governance of Indigenous nations. That's for another time, and I've spoken about that a lot. But here we have the situation in the north where, with a couple of exceptions, there have been no reserves set aside. So, on the face of it, the head tenant, the Crown, is currently exercising these rights of head tenancy over all of those areas. Now, there have been land claims entered into, and you'll see a typical chart here where the setup has been a land claim settlement agreement, which is not a treaty, which is a domestic agreement, and reflects, unfortunately, in and of itself, the way these things are documented, supports a finding that the Canada and the government of Northwest Territories will hold, that the people who've signed into these are no more. They may be Dene culturally, if you will, with games and cultural ceremonial celebrations. But what's lost is Dene sovereignty, Dene underlying title ownership, and all of the rights that come with that. That's because these are done under a Section 35 doctrine. And that doctrine holds as a starting premise that the Crown owns everything. Why? Because it's a doctrine that's been created by her courts. Her courts has to operate as if she does hold underlying title. It has no jurisdiction to question that. It must proceed on that assumption. This is why you've had such incredible efforts and ridiculous kinds of outcomes to try to say, well, how did she come to have title here, especially when there's no treaties in the areas. I said, oh, well, she just has to assert the title. So acting what's called de facto, making it look like they have the title over time should be sufficient. And if you opt into the Section 35 doctrine, either by way of land claims or by way of litigation, then you're accepting that premise. That's not the intention that I have seen expressed by Dene people. And many still believe that their sovereignty remains unaffected. Technically speaking, only the Decho, because they haven't entered into a land claim or self-government agreement yet, are dealt with as if they have. And they pose some of the greatest threats to this plan because they've held out, if you will. Now, this is not to criticize those that have done these other deals. With respect, I don't think they fully appreciate what those agreements do if that's all there is. And that's my big warning. That if you allow those to stand and speak for you and there is nothing else, then here's what it looks like. This is the current example. Look at this chart. This is how Canada and the government in Northwest Territories have operated so as to achieve underlying ownership. You'll see that basically you have the government of Canada, and beneath that you have the government of the Northwest Territories. Then beneath that you have, as a result of land claim settlements and self-government settlements, you have corporations that have been incorporated under GNWT, and they're holding fee simple lands. Now what does that mean? Remember, underlying title still Dene. Head tenant, the Crown. The Crown then issues lesser estates in its interest. What are those lesser estates? Fee simple estate. That's the highest level of quote-unquote ownership that Canadians can get under the lands that are properly owned by tenancy, not by outright ownership of underlying title. There's a distinction. So those fee simple lands has, everyone who's been into this system now, all of their land holdings are considered to be beneath the government of Northwest Territories and beneath the Crown, beneath Canada, because they're no longer being held as, for example, reservations out, reserves of Dene land that retain their full jurisdiction. With the one exception there, KFN just did a code, they did a land code that put them under that jurisdiction, federal jurisdiction, that actually creates them as a new corporation. And so, unfortunately, while those are reserves, they're actually now in a different kind of class called surrendered reserves. The federal government keeps track of those reserves that are fully surrendered as a result of passing the land code and coming under the First Nation Land Management Act. So you have presently this setup whereby, in addition to these basically municipal fee simple structures all coming within government of Northwest Territories, government of Northwest Territories, of course, also has received devolution. So over the 80% of land that's still Crown land, the GNWT is making decisions for that now, including resource revenue sharing. Which, when I look at that deal, it's kind of trite to say, a percentage of zero is still zero. The terms, I would suspect no one's really gotten much, if anything, under the way that's been structured. So you also have, now with that setup, you'll see that the Treaty 11 is disconnected and it's considered historical. It was there, but now we have these new things. And then you see also kind of disconnected is the Dene Nation Corporation. Now they go just by Dene Nation, but technically they are a corporation and their name is Dene Nation Corporation, affiliated then with the Assembly of First Nations, which is also a corporation, and both of those are basically lobby groups. But again, with nothing else in existence and functioning here, who are they lobbying for? Well, they're lobbying for domestic ethnic minorities that are quote-unquote descendants of Dene. What I speak about is a continuing Dene Nation with Dene nationals alive and well today, exercising and protecting their lands under their laws, but having this relationship that must be respected by treaty, appreciating that the Crown has this head tenancy right under her lease. Now, what does that mean? Well, what's missing in this picture, and I'll just put this up now, to show that, well, Dene still retain underlying ownership of the entire area. There is no visibility of that. In other words, in the absence of being seen and heard and speaking in the context of being nationals of Dene Nation, as opposed to being subject to corporations that are governed by GNWT, for instance, or Canada in the case of AFN. There is nothing at this top level, and it's at this top level where there needs to be a Dene Nation, a true Dene Nation structure into which a sovereign wealth fund flows. So that's top level. That means when there's taking up of land that is lawfully possible for the Crown to do, there does need to be this compensation. You can't just take land, you can't remove land. Taking up and removing land is different, so mining is a very complicated area in that sense. There should be not just a GNWT from its tax base or what have you, granting a minuscule amount of resource revenue sharing. There needs to be a direct off-the-top input from these kinds of developments that go to the Dene Nation as a whole. There you will have, you'll see Treaty 11 is very much alive and well in governing all of the interactions here. And then you have, of course, the Crown, and you do have these other corporations that have been set up under land claims and self-government agreements. And they don't have to be undone or try to be undone or pointed the finger at. But you'll notice they are protected by the umbrella. Where's the Dene umbrella? Where is that overarching authority into which all of these different structures should be funneling their input and decision making? And for example, here, turning specifically to Decho, deciding to not deal with lands because they don't want to sell lands, they don't want to give up, they don't want to give up their lands. But the problem here is that different acts that have been passed, legislation that's been passed, and agreements entered into, are actually dealing with you as if you have entered into something like this. So they're doing this de facto game with you, this de facto dance, where it says, okay, well, we'll just treat you like this. We'll give you a spot on the board in terms of McKinsey review board and things like that. And over time, you know, without having a land claim agreement in place, without having reserves selected and set aside, it'll just, you know, there'll be sort of this assimilation that happens. And without protecting against that, and there's very simple ways I've shared in the past on how to ensure that Canada and the Government of Northwest Territories commit to not exercising certain provisions and agreements that they are not a party to. That should be a simple ask and a simple give to as a condition of proceeding with negotiations. Now, the DHO can decide whether they want to simply have these kind of corporate structures, or they, and I would encourage, to have a DHO structure that uses corporations for certain functions, but it itself is not an incorporated entity under the Government of Northwest Territories. If it does become an incorporated entity under the GNWT, it's not the be-all and end-all, it's not the end of Dene. As I've indicated with, you know, everything that's already been done, it's not necessary to undo that, but it is necessary to put it into context and to ensure that all of this, however it is structured in terms of the dealings on the ground, all of it is remembered and clearly established as being under Dene law. And everything that flows that involves Canada and the GNWT is all part of and subject to Treaty 11, for example, and all subject to and required to comply with the law of the land, which is Dene law. If you look at that treaty, you will see that the commitment, and here's another part that I'm putting up. You will see that under Treaty 11, that referring to the Indigenous nations here, they promise and engage that they will in all respects obey and abide by the law. It doesn't specify His Majesty's law. The law. Remember, the law of the land is Dene law. And under that law, a treaty has been entered into with the Crown. Also says that they will maintain peace between themselves and others of His Majesty's subjects, and that they will not molest the person or property of any inhabitant, and they will assist the officers of His Majesty in bringing to justice and punishment any Indian offending against the stipulations of this treaty, or infringing the law in force in the country. And it says so ceded, but remember, the country itself is not ceded. It's the land use by individual or groups of Dene nationals that is set aside. Underlying title remains with the Dene unless the Dene decide to give it away or abandon it. Again, you abandon by entering into agreements that suggest that you embrace the concept that only the Crown owns. But how did that happen? Because that certainly didn't happen by treaty. The treaty sets out a lease, and it says that lease is forever. And I remind you that even under Treaty 11 here, that to suggest these land claims agreements, self-govern agreements, and other deals and stuff that Canada and GNW want to put in place so as to have whole control, to suggest that that's the way to go, remember, that breaches treaty in and of itself, because you're supposed to comply with the treaty. And complying with the treaty is recognizing, remember, the Crown, the King, recognizes the Dene sovereignty here. It recognizes the ownership of these lands by Dene and requests to have a head tenant status and receive that head tenant status under Dene Nation law. And compliance with the treaty requires, this is for all time, and this is why, for instance, Lord Penning in England, in London, when chiefs went to visit him, worried about, Constitution Act 1982 coming into that would be passed. Lord Denning was very clear. What are you worried about? You've got the treaties. They're clear. Well, just as I look at them as well, any trained lawyer of those times understood what they're looking at. To have and to hold, it's plain, it's clear. It's only the big lie, the big misrepresentation that Canada has said, oh no, that's not the case, you sold your lands, you gave them away. Some people recently, I've even been hearing, are saying, oh, you gave up in 1960, it was all over, so, you're already gone, so you might as well do these deals. My goodness, what a lie. What happened in 1960 was the government of Canada simply conferred and deemed Canadian citizenship on all Indigenous nationals. Basically handed them a second set of rights. Does nothing to undo the fact of still being an Indigenous national, still being Dene, true Dene, not just appearing in a national kind of costume and in exercising certain rites and ceremonies, etc., but the whole ball of wax, the whole power, if you will, of the laws. Now remember that under Dene law, you need to protect that land for future generations. Most Indigenous nations say 7 generations hence. And that is the top law. The Crown must comply with that. There are all sorts of ways to ensure that your country is not going to end up the wasteland that many have targeted for. Remember, you've got huge sources of water. You've got huge sources of rare earth minerals, all in high demand. And unless you are able to come to terms with the fact this is still your land and your responsibility, and you are to enforce your laws and protect your lands, notwithstanding what your head tenant is doing and those who act through the head tenant, it's a requirement that you not say, okay, yeah, I guess it's yours. There are consequences to that. And I don't think I need to harp on that very long. The fact is, these are your responsibilities. and without trying to dismantle everything that's been put in place. Now is the time to clear up things like bylaws and constitutions in corporations that are trying to be more than they are. Use them as tools, clean them up, and make sure they're not trying to take away governance power that rests with the nation proper. And set up your proper focus on the fact this is all still Dene. And while we have different areas that are under certain agreements and certain municipalities are set up and these simple interests under the governing Northwest Territories in Canada have been established, that still does nothing to take away from the fact of underlying ownership in the Dene. But unless you clean up some of this stuff, and unless you really get clear about the order of what's real, as opposed to accepting how Canada would like it to be, how the government of Northwest Territories would like it to be. Remember, you are no longer the majority of people in this part of the world. And the only thing that's going to protect you from the extreme demands that will be coming is for you to retain your responsibilities for your nation, for your land's resources in all your relations. And I hope that this has been able to help you focus again and really hear what the elders have consistently said. This is our land. We are not giving it away. We are not going to abandon it. And I pray that the people will come together to understand that you are where you're at because you were severely interfered with. There is such effort to take what you still have. You don't have to give up. You are actually in one of the most powerful positions in the entire world if you know how to exercise it in that right way and not be speaking as if you are a domestic and writing as if you're a domestic ethnic Canadian minority only. And that's all I have to say.